Mr. Piyush Goyal.
Thank you, Mr. Chairman. I am grateful to the Honorable Minister for giving a brief preamble of why he chose to bring in these amendments. But I am extremely surprised to note from him that he has based this amendment bill based on the recommendations of the expert committee, and a lot of the provisions have come in from the expert views of the standing committee. In fact, when I read the views of the standing committee on the amendment bill, I was most surprised to note that most of the recommendations of the standing committee have been completely ignored by the government while proposing the new amendment bill that they have brought up before the House today. And I will come to each of those specific issues. But at the outset, I would like to speak a little bit about the broad overview of the mentality of this government, sir, to control all statutory bodies, gradually bring everybody under bureaucratic control. And when we talk of reform, this government believes that they are votaries of reform. The only reform that they can think of is FDI. Instead of bringing in reform in our administrative procedures, in the systems of government, de-bureaucratizing the system of government, instead of making business liberal in the country, this government is trying to centralize all powers within bureaucratic hands. And that is the primary reason why we object to many provisions of this bill. We believe this government and the Department of Education and Human Resources Development is, through the mechanism of this bill, bringing in so many powers that the Council of Architecture will be redundant, will become a redundant body. It will have no powers whatsoever to function independently and autonomously, and will remain an adjunct of the babus in the government who will decide, you either do this or, and then the or is what bill. So completely taking away the autonomy of an independent body set up by an act of parliament 35-40 years ago is being sought to be taken away by this act. Sir, the Honorable Minister spoke about the group of experts. I went into the report of the group of experts. I found that the group of experts did not give an opportunity to the Council of Architecture, against whom this report was made, to even present their views before the committee, before the group of experts. So it's a completely one-sided group of experts set up by government bureaucrats with the intention of getting a certain report which suits their convenience, and using that report today in the garb of that report, this government is coming out with an amendment bill. I would like to know from the Minister, this committee of experts, who nominated the members, what was the criteria, whether they gave opportunity to the affected parties to appear before them, and whether they took cognizance of the real facts of the case before they came out with their recommendations. And on 2 or 3 of the issues, I will highlight what the committee did, what the group of experts did. The second clause that they want to amend is the power to supersede. I am grateful that the Minister has acknowledged that unrestricted and unfettered powers to supersede should not be a part of the law. And I'm glad that at least there's some restriction on the government to centralize authority. But sir, the power to supersede by to be followed up by a commission of inquiry, which commission of inquiry will have 2 members of the central government, is once again the same thing. So if the government makes up its mind to supersede the body and appoints 2 people on that body, they can take any decision and come to a conclusion that this body needs to be superseded. So I would urge the Honorable Minister either to remove this power to supersede. There are so many professional bodies, sir. I am a chartered accountant. You cannot supersede my Institute of Chartered Accountants of India. You cannot supersede the Institute of Company Secretaries. You cannot supersede the Institute of Cost and Works Accountants. Then why then the architects body should be subject to supersession by the government? If there are malpractices, if there is action to be taken, there is a due process stipulated in the Act. There are rules and regulations, therefore. I don't see any reason that the power of supersession needs to be taken by the government. And if at all there has to be a power of supersession, the Commission should have members, maybe sitting or retired judges of the High Court, or some such stipulation to conduct impartial inquiry into the working of the council, rather than have bureaucrats appointed by the government as members and chairperson of that council. Sir, on the third issue, by way of a subsequent amendment, the Honourable Minister has sought to say that in Section 6 of the Principal Act, that within a period of 15 days from the date of receipt of information from the returning officer. So what they are trying to say, sir, is that the name and address of each member of the council elected shall be notified by the central government within 15 days from the date of receipt of information. That means the returning officer can sit over the information for years together, and the government will not appoint anybody. There will be no notification in the Gazette. So it's again centralizing the power on the government's hand to decide when to announce the result of the election and to appoint the officer. So I would urge the Honourable Minister to amend that to say within 15 days from the declaration of the result. Why should it wait for the central government to receive a letter from the returning officer? Once the results are declared after an election, within 15 days the government should appoint them or notify them in the Gazette. There is no reason for this to wait for intimation by the returning officer. And if at all he has to intimate, there should be a time limit that he will intimate within 2 days or 3 days of the declaration of result or the conduct of the election. Sir, on another issue, as I mentioned earlier, the chairman of the commission should be a member of the sitting or a retired judge of the High Court, because otherwise that commission will have completely one-sided views. The other issue that they have brought out in the new amendments in 2011 is the amendment by which, after the commission makes recommendation, the central government can amend the regulations. Now, I fail to understand how the central government can amend a set of regulations which they did not have the power to formulate in the original instance. The power to make regulations is with the Council of Architecture. They make the regulations, get the approval of the central government, lay them before the table of the House so the honourable members can go through it and approve it, or have any questions can raise it, and then they are passed. Now, how can the central government choose that they want to override those amendments and amend those regulations? I think the central government cannot change the regulations. They can at best give directions to the Council of Architecture to amend the regulations. So no, there's one very important point which doesn't come directly in this bill, but it is very relevant because the mindset of the government comes out in that. Sir, this government has a department called AICTE that was formulated to control and regulate technical education in India. That body, generally I've read the whole act, talks about management and technical education. Innocuously, one word in the whole act, the architecture word, is used only once. Whereas the original Architects Act 1972 has 7 clauses which deal with architectural education. And they are duty bound to regulate the conduct of examinations, the qualifications, everything related to the architects has to be handled by the Architects Act.
Okay, now wind up please, because your party has 2 more speakers. That's the point.
Now,
2 more speakers.
If AICTE were to regulate and architects were to regulate, there would be a problem. So an MOU was entered into between AICTE and Council of Architecture, and very smoothly the process was going on. Suddenly this government decided to cancel that MOU and want to take the entire powers of education in the hands of AICTE. This matter, sir, was referred to the Honourable Additional Solicitor General of India and the Attorney General of India. A person as illustrious as Shri Soli Swarabji has opined that when there are 2 conflicting acts, normally the subsequent act will prevail. But when the provisions in the prevailing act, the original act, are specific on a particular subject, then that act will prevail. Now, why does this government want AICTE to control such a specialized profession as architects? They are hardly doing their job well on what functions they have been given. There are complaints galore that all of us face every day in and out from educational institutions. I have an illustrious educationist sitting here on our benches. the problems that they face getting even a small approval from AICTE, and you want to add even the architects going there. Tomorrow he will add chartered accountants, cost accountants. I don't know if he will have the guts to, if he will have the wherewithal to add the lawyers also under AICTE.
Okay.
That would be the day when the government comes out with lawyers coming under AICTE.
Okay.
I think the architects need to be given
Yes,
due
conclude.
justice.
Please conclude.
I think the education should be left to the architects to regulate
Okay.
and control, and the government should immediately once
Okay.
again reinstate that MOU
Yes.
between AICTE and council and let the
Yes.
council conduct.
Okay.
And one last thing, sir, the last point, sir, the government is talking about internationalizing architecture. It's a very noble thought. I am a votary of free business and reform. But sir, the problem with this government, as my leader had mentioned 2 days back in this house also, the problem with this government is they are willing to give away everything without taking anything in return from the other countries. So even in the case of architects, we in India allow foreign architects to practice here, subject to certain qualifications or subject to certain qualifications from listed entities. But no other country in the world recognizes architectural education in India and allows Indian architects to practice there. So what liberalization? $3 trillion business, they just want to hand it over to foreign architects?
Yes.
I think the Indian architects deserve better.
Yes, yes.
They are world class, and this government should believe in reciprocity.
Okay.
And no rule should be made in which the Indian architects are disadvantaged
All
over
right.
the foreign architects.
Okay.
Thank you very
That's
much.
all. Thank you very much. Thank you. Now, Sri Shanti.